Good afternoon, everyone. Welcome to our April 12th webinar on amendment versus resolution. Which do we pick? My name is Alina Gilbert. I will be presenting today. And before we get started, we're going to just do a couple of housekeeping things here. So for those of you who have not participated in one of our webinars before, welcome. Glad you're here. On your screen, you should pretty much, the bulk of it should be the PowerPoint. And then on the bottom right-hand corner is me. Hello. And the other thing you should know is there is also some icons on the left side of your screen. One of those is a little talk bubble with a question mark in it. This is where you are going to type in your questions, should you have any, as we go through this presentation. We do have a lot to cover. I'm going to save questions for the very end, but you'll also have my email address at the end in case I don't get to all the questions, but I'm really going to try and get to everything today. So this class is going to give you 1 CMCA credit, which will be emailed to you within a day or two after the class, once we receive verification of all the attendees from the webinar provider. If you don't see that email in the next couple of days, please feel free to reach out and let us know. If you're having any kind of technical difficulties or questions that have nothing to do with the webinar, but have to do with the technical side, please email Summer Sims, who is our education coordinator, at sims@altitude.law, or give her a call at 303-991-2076, and that's her direct number, so she should be there. Okay, I can't help you on kind of my end because A, I don't know anything about IT, and B, I'm teaching the webinar, so even if I did know something, I still couldn't help. So please just go ahead and reach out to Summer should you need anything technical. Okay, so without further ado, I am going to get started because, like I said, we've got quite a bit to cover. So this class is really created because we see a lot of questions from boards and community managers saying, hey, we want to do X, Y, and Z. Is that something we can do through a rule, or what do we need to do to be able to do this? And generally, it's, can we do it through a rule, or do we have to amend our documents? And so this class is intended to really kind of help you decipher that, not necessarily avoid asking your attorney, but at least give you an idea of the type of things you should be looking at when you're trying to decide what you want to do. Okay, so before we get really into the nitty-gritty, it's important to understand that each of our governing documents has a specific purpose, and there's also a specific hierarchy that we have to follow. So in other words, if you look at the little check marks below, you'll see the declaration, the map are on the top, which means they're at the top of the hierarchy, and any document that conflicts with a document above it, you know, the top document's going to trump that. So to the extent there's any discrepancy between bylaws in your declaration, the provisions of the declaration are going to control the provisions of the bylaws, etc. So just really quick, the reason we have the declaration and the map together is because under Kiowa, there's actually a provision that says the declaration includes the map. So we know that the declaration and the map are two separate documents, but from a hierarchical perspective, they are one and the same, and so they hold equal weight. So any document underneath the declaration and the map that conflicts with the declaration or the map is not going to, it's going to be subsidiary to that. If there's an amendment between the map, no, not amendment, see. If there is an inconsistency between the map and the declaration, then we really have a problem because neither one of those trumps the other one. So make sure you talk to your attorneys if you see that kind of thing happening. But in general, the purpose of the declaration is really, this is the document that impacts our homeowners' rights. This is the document that tells homeowners they have to do things like pay assessments, get ACC approval, and that they can't do things. You can't paint your house purple. You can't make exterior modifications without approval. I mean, so basically it controls their rights as homeowners. And this is the really most important document when it comes to our homeowner rights. And so it gets recorded with the clerk and recorder's office. It binds all property owners who purchase in the community, and it's a very important document. The Articles of Incorporation are a corporate document, and they just create our nonprofit corporation. They get filed with the Secretary of State's office, and they really have, a very limited use. Bylaws don't get filed anywhere. They are an operations manual. They should be answering questions on how do we do things, how do we call a meeting, how do we elect directors, how do we appoint officers, that type of a thing. So that should all be in your bylaws. And I am rushing through it because obviously the point of this class isn't necessarily this. And then at the bottom, we got our policies, rules, regulations, guidelines, whatever you want to call them. They're all basically on the same level as each other. And they're at the bottom, which means if there's any contradictions between these documents and either bylaws, articles, deck, or map, then the rules, policies, etc., are not going to be enforceable. They're not going to be lawful. Okay. So what fun would it be if I didn't throw in a few monkey wrenches for you guys and said, hey, the other kind of side of the coin here is we also have a whole bunch of laws. We have statutes, both on a state and a federal level, which are, this is by no means an exhaustive list, but these are some of the primary statutes that we do deal with when it comes to governing an HOA. And sometimes these statutes will trump all your documents. For example, sometimes they're going to say, this is how it is. And if you have something contrary in your declaration, it's just not enforceable. Sometimes these statutes say, well, unless otherwise provided in your declaration, it's this, right? So you're not always going to know which one it is, which is yet another reason why you're going to ask your attorneys. But sometimes, regardless of what your governing documents may say, perhaps it's still something we can't do because it's not allowed by the law. So that is always kind of the underlying question is, do we adopt a policy? Do we amend the declaration? Or can we even do this, whatever it is we're trying to do? And that is going to be dependent on state law and federal law, depending on what you are trying to do. All right, so we got it in general now, but let's talk about some rules of the road when it comes to our policies, resolutions, rules, etc. I did a class, I don't know if it was a month or 2 months ago, about the difference between rules, policies, resolutions, and all that good stuff. For the purposes of this presentation, I'm really using these words interchangeably, rules, policies, resolutions, because they are, like I said, on the same playing field as each other. Legally, they are equal to one another. None of them kind of precede the other ones. So I'm going to just use it interchangeably. But when you're adopting your rules, there's certain things you cannot do. And I think a lot of this is probably going to be, yeah, we already know this, Alina, but I'm going to tell you anyway, because again, we got to get the foundation down here. So as I said earlier, your rules cannot conflict with anything in the 3 primary documents. So your declaration, your articles, and your bylaws. And of course, I'm including the plat in that as well to the extent that there's anything in there. So can't conflict with anything in your 3 primary documents. You cannot create requirements without some general authority in your primary documents. And by the primary, I mean the 3 that I just talked about. So what's a good example? So I actually had this question come up this morning, and it's a great example. I had a manager ask me, she said, the board wants to know if they can adopt a rule requiring owners to park their vehicles in the garage instead of somewhere else. And I had to say, well, it depends. It depends on what your documents say and whether there is some broad authority for the association, A, to control parking, B, to control the garages. I didn't know, for example, if this community was a condominium community where the garages and the parking areas are all common elements, or if it's a single family community or a townhome community where the homeowners actually own the garages. And so who really knows without looking at the documents? I said, we got to have some general authority to regulate people's use of their lots, parking, something along those lines that we could fit it into. And so if we're talking about single family homes and there's absolutely nothing in the covenants that say we get to regulate the lots and all we get to regulate are common elements, then arguably we shouldn't be adopting any rules, okay? But it all depends. So we can't have anything that conflicts with the law. As I said earlier, we have a lot of statutes, so we want to make sure that whatever we're doing does not violate any requirements or any prohibitions within Colorado and federal laws. There's more. I hope you guys are reading the memes because these are hilarious. Okay, what else can't we do with our rules? We can't create exceptions. What does that mean? Well, let's say you have a declaration that says boats may not be parked in the community. And the board says, well, we're just going to allow it as a temporary expedience, right? While homeowners are bringing their boats in, and we'll let them keep it there for like 48 hours, and then they have to move it. That's an exception to the no boats in the community covenant. And so we can't do that. That is not something you can do by rule. This is an example of when you would need to amend the declaration to allow either for exceptions to the covenant or to just remove the covenant. So we can't grant or we can't create exceptions to very specific requirements in the covenants. We can't add use restrictions. So what's a use restriction? So that's the $1 million question, really. We don't have case law, especially not in Colorado, defining exactly what it is. But there are a couple of things that kind of attorneys around the country agree as far as what it entails. One is leasing. Any type of leasing regulations is considered a use restriction because leasing your property is a fundamental right of property ownership. So anytime you are thinking about adding some leasing restrictions for your community, almost 100% of the time, it's going to be you have to amend your declaration. Not all the time, but most of the time. There's certain things, you can do with leasing, such as like if your documents say you have to provide a copy of the lease to the association, you could have some sort of a rule saying, the lease needs to be provided within X amount of time, and this is how you submit it. But you can't have anything, really beyond that. Another item that is considered a use restriction that you're not going to be able to do through a rule is to tell homeowners, is to dictate what homeowners can do inside their units. Now, if it impacts the exterior appearance, I think we can do it, like the window shades and things like that. But without specific authority, you're not going to be able to have a rule that says you cannot smoke in your unit, okay? Because that's not something you can do through a rule. That would be a use restriction. We can't be more restrictive in our rules than we are and than what we have in our covenants. So if the covenants say, a homeowner has 60 days to submit an appeal to an architectural denial, we can't have a rule that says you have to do it within 30 days. That's more restrictive, and they have a 60-day window in the covenants, and therefore we have to comply with that. Oh, I just realized we have use restrictions in here twice. So ignore that one. We already talked about use restrictions. That's hilarious. And the last thing is we can't add board powers. So the board can't give itself the right to, for example, go inside units to inspect them for violations. If your covenants don't speak to that, you as a board do not get to give yourself a power to do something you're not authorized to do through a rule. Okay, so these are all the may nots for rules. But there are some mays. Let's talk about what we may do through our rules. We may define ambiguous terms in the documents. It's kind of like the two pictures on the right, both somewhat ambiguous. So if you have an ambiguous term in the document, in your declaration, you can have a rule defining it. So for example, you can have something like no loud noises. We've seen that in documents before, no loud noises. Well, the board hypothetically could adopt a rule or a policy that defines what a loud noise is in decibels if it wants to, or they could define it as a noise that would offend a reasonable person, give it a little bit more clarification. That's something you can do through a rule or a policy, okay? You also can clarify vague provisions, which really is very similar to the ambiguous terms, but terms are basically one or two words. Provisions are in general, like specific sentences where homeowners may not act inappropriately in the community. I mean, have you seen something like that? It's like, what the heck? What's inappropriate to me may be very appropriate to someone else and vice versa. So what does that even mean? Those are the types of things we want to see clarification on through rules and policies. You can add processes to accomplish what is allowed in the documents. And probably one of the best examples of that is your collection policy. Your declaration already speaks to assessments and collecting assessments and sets forth some parameters, but your policy goes into a lot more detail and creates the actual process and the step-by-step of what the association has to do to collect the assessments, to be able to comply with what the documents require it to do. You can set expectations of conduct on common elements. So unless, and this is unless, your declaration specifically prohibits you from doing that, which I have never seen. Kiowa specifically says the board does get to adopt rules of conduct or rules in general. And the board and the association controls the common elements and what happens on the common elements. So again, we can create a rule that says, you can't leave your bicycles out on the common area overnight. You can have a rule that says pets must be leashed when on common area. Okay, that's all appropriate, even if your declaration doesn't speak to that. And then govern the use of common elements. Okay, so that again is very similar to the conduct, but so the conduct is how you act and the use is how you can use it. So technically, the example of the dog on a leash is more of a conduct. And then the use could be, owners may not have picnics on common area. That's conduct also, but it's also use. So you get how those all blend. But those are all things that you can do through rules. Okay. But really, the short of it is if you can't do it through a rule, you need to amend. With the caveat that sometimes you just can't do it because the law doesn't allow for it. So, but ultimately, this is assuming you can do it legally through, the law doesn't prohibit it. If you can't do it through a rule, you need to do it through an amendment. And that's really the rule of thumb. So rather than me continuing to lecture about this and tell you what you can and can't do, I think the best way, for us to really look at this is through real world problems and through real world examples. And we got pretty much the rest of this class is we're going to be looking at this stuff and looking at the analysis. And just know that these real world problems, most of them I took from actual situations and actual provisions and declarations. However, in the real world, it's usually much more complicated than just the declaration states X, because typically we're looking at a whole bunch of different provisions in the declaration. But for the purposes of these exercises, we've simplified it. So, association maintains exterior building surfaces of the residences, and the association wants to require owners to paint the siding. Is that something that they can do through a rule, or do they need to amend their declaration? So in this case, if you guys are thinking that they should amend the declaration, you're correct. Although the term exterior building surfaces is ambiguous, and we're not exactly sure what it might and might not include, we can definitely be sure that painting is maintenance of a surface, okay? And I don't think you can interpret maintenance of exterior building surfaces to exclude painting. So this is really an association obligation that cannot be shifted to the homeowners while this particular language is in there. The association maintains exterior building surfaces of the residence. We cannot shift the painting obligation of the siding to the homeowners. So let's look at a slightly different angle here. Same declaration, association maintains exterior building surfaces of residences. Association wants to require owners to replace the siding. Now, what is this? Do we need to amend the declaration, or can we do this through a rule or policy? I think you can do it through a rule or policy. Because the term exterior building surfaces, we don't know exactly what it includes. If it's truly just the surface of the building, obviously it's including paint, right? But if it's just the surface of the building, then removing the actual siding piece goes beyond the surface. Now we're actually taking out a component of the building, an exterior building component. We're not just doing anything with the surface, we're taking the whole thing out now and replacing it. So is that something that could be shifted to the homeowners? I think if a board adopts some sort of a resolution clarifying that the exterior building surfaces is truly that, just the surfaces, which means the association paints, stains, maybe even fixes if there's cracks, but the homeowner is responsible for actual replacement of the siding. I think that is well within the association's purview to be able to do through a resolution. And so you can see that depending on what the board wants to do, in one case we would need to amend, but in another case we could probably do it through a resolution. All right. Another great one. No pets in the community. That's what the deck says. Association wants to allow assistance animals. Is it going to amend the declaration, or is it going to adopt a policy? So this is really, really a trick problem, because now we're also dealing with state and federal fair housing laws. The answer should really be neither in this one, because first of all, assistance animals are not considered pets. So you don't need to create any kind of an exception to the no pets in the community provision. However, we also have both state and federal laws, in this case, that require associations, as a housing provider, require associations to make reasonable accommodations or modifications so that disabled owners or residents can equally enjoy the premises. What does that mean? It means a reasonable accommodation means we have to make a change or an exception to the rules or to the covenants. And I know earlier I said we're not allowed to make exceptions to the covenants, except when the law requires us to do that. And the law says if you've got a disabled resident, you have to do this. So there really is no such thing as a no pets community or a no animal community, because there are so many types of assistance, animals out there that people have. So you don't need to create an amendment to the declaration because the law already does that for you. You don't need to adopt a resolution clarifying that assistance animals will be allowed because, again, the law already tells you you can do that and we have to allow it. But what can you do as an association? Well, with these types of situations, you can adopt a policy that talks about the process for requesting and obtaining a reasonable accommodation or modification. And usually we do actually recommend having these types of policies on hand for your homeowners who do want to know, how can I get my emotional assistance animal or my seeing eye dog or whatever into the community that has a no pets or no animals restriction in the covenants. So that's something you could do and should probably do is have that kind of a policy, but you don't need, and you certainly don't want to have anything saying, oh, but we'll allow assistance animals, because that's too narrow. It really is too narrow. And what you're essentially doing is you're pretty much saying we'll allow assistance animals, but you're not covering every type of animal, assistance animal that can be covered by this term. And so the problem is it's going to be viewed as discriminatory because you're only saying we'll allow assistance animals. What about other types of animals? What about the seeing eye dogs? What about, the hearing impaired? So there's different kinds of assistance animals and they go by different terms. And so you just want to be careful when you make these types of exceptions, because inadvertently what you might be doing is violating fair housing laws. All right. Another great one. Vehicles may not be parked in driveways overnight. But the association wants to make an exception for overnight guests. So if you've got someone out of town visitors and they're coming for the weekend, the association thinks it's reasonable to say, well, they can park on the driveway while they're there. We can make them get a permit or whatever else we want to do. Well, the problem with that is the way this declaration is written is it just prohibits vehicles on driveways overnight. Now, if there was additional language in this declaration that said vehicles may not be parked in driveways overnight except with prior written approval from the board, that's fine, because then the board could approve it. But if this is all there is and there's no provision allowing the board to make exceptions and approve certain situations, guess what? This board cannot make an exception for overnight guests, even though we know it's a reasonable thing to do and it's probably the right thing to do. But when you've got covenants that have provisions like this that are either not being enforced or outdated or don't really apply to your community anymore, that is a sure sign that it's time to amend, because a board has the duty to enforce its covenants as they are written, whether they like it or not. It doesn't matter if you agree with this covenant that prohibits overnight parking on the driveway. You don't have to agree with it. You have to enforce it. And so when you get to the point where your board's not wanting to enforce this, you definitely want to start looking at an amendment, because you're not going to be able to change it through a resolution or a rule. Another good one. This is real. This is a real provision, and I've seen it in a few documents, but it says leases are allowed, including leases for 30 days or longer terms. Okay. You could probably take out the word terms. Leases are allowed, including leases for 30 days or longer. Okay. So the association wants to prohibit vacation rentals. So that would be RV, RVOs, things like that, right? So can they do that with a rule, or do they have to amend? So this is tricky, and this one always gets associations pretty upset with me when I tell them, no, you have to amend. If you're looking at it and you're like, what do you mean you have to amend, Alina? What do you What are you saying? I'm saying you have to amend. If you look at the way the declaration is actually written in this particular case, it says, so you got to break it up. Leases are allowed. Leases are allowed. That could be a sentence on its own, right? Then it gives you an example, including leases for 30 days or longer. So this is just an example of the type of lease that is allowed. Do you see anything in this language that says you can't have leases for less than 30 days? No, you don't. And there's no implication of that. Just because we give an example of a 30+ day lease as what you can do, that doesn't negate a homeowner's ability to have a lease that's less than 30 days. And that's really the problem with these types of provisions, is when people look at them, they're like, oh, okay, so leases less than 30 days are prohibited with this provision. They're not at all. They're just giving you a stupid example of a lease that's allowed. There's a million other types of leases that are going to be allowed too. So can the association adopt a rule prohibiting vacation rentals? The answer is no, they can't. This is something that has to be an amendment to your declaration and has to go through the homeowner approval requirements in order to be adopted. All right, decks. Let's talk about decks. Decks are limited common elements. This is what the declaration says. Owners must keep their decks in a clean and neat condition. Association must maintain common elements. All right, so the association wants to require owners to repair the decks. Can this be done through a rule, or do we need to amend in this case? What do you guys think? So the answer is you have to amend. Why do you have to amend? Well, when you look at the words clean and neat condition, that means you're cleaning the deck. It means you're not piling stuff up on the deck. There's nothing that implies or mean clean or neat. Neither one of those terms imply good condition. None of them imply good repair. Okay, so when we see another provision that says, hey, this is a limited common element and the association is required to maintain common elements, whenever you see the word maintenance, you should assume it includes repair and replacement and upgrades. Not always upgrades, but at least repair and replacement. And unless there's something to the contrary in the declaration. So when we see association must maintain common elements, what we're really seeing is, okay, so limited common elements are common elements. They're still common elements. And there's no exception, at least in this set of provisions, that homeowners have to repair their limited common elements. All we know is that owners have to keep their decks in a clean and neat condition, right? But the association has to maintain the common elements, which includes the decks. So if we want the owners to repair the decks, we would need to rewrite some of these provisions in the declaration, and we would probably want to say something like owners are responsible for the maintenance, repair, and replacement of their decks. And then this provision about the association must maintain common elements, we probably want to clarify, except as otherwise provided in this document, association must maintain the common elements, because we've just created an exception. So we don't want two provisions of the declaration contradicting one another, right? Because then we have a bigger problem. So again, that would be the answer in this case. So you would want to update those two provisions if you wanted to shift the maintenance obligation to the homeowners for their decks. But just remember, when you're updating the declaration, you got to get homeowner buy-in, because you're going to need homeowner approval, right? So sometimes we know that that we are going to present to the homeowners are going to be very difficult to sell. So kind of have your plan in place as to how this change is going to benefit each homeowner, because they're not going to approve it if they don't see a benefit to them. All right. Declaration says owners may have a reasonable number of pets. Association wants to define reasonable number as 0. Do we amend or do we adopt a rule or policy? Okay, I'm hoping you're all thinking amend. I really do. I use this example a lot, so if you've heard me use it before, I'm sorry, but it's just such a good example of a situation where the declaration doesn't specifically state each owner's entitled to have a pet, but it does, right? Owners, when you're saying owners may have a reasonable number of pets, it's essentially saying you're entitled to have at least 1 pet. So to define the term reasonable number as 0, what you're doing is you're changing the declaration from you're allowed to have at least 1 pet to you may have no pets at all. And that's a conflict, right? It's a conflict with what the declaration says, and therefore you cannot do it through a rule. You can only do it through an amendment. Feel bad for this poor little hyena. So cute. Okay, more fun ones. Declaration states, prior to installing exterior improvements, owners must get written permission from the DRC. And then improvements are defined as landscaping, equipment, privacy fences, pools, basketball hoops, decorations, etc. And now the association says it wants to prohibit privacy fences. Okay, so you are correct if you're thinking, well, there's nothing here that says owners are entitled to install privacy fences. It doesn't quite say that, but it does. Because it says, if you break it down, homeowners can install improvements, which includes a privacy fence, if they get written permission from the DRC. So the DRC, or the association, can create requirements for privacy fences, right? But it can't just prohibit privacy fences because the declaration contemplates that privacy fences are improvements that owners can request. And you can't deny homeowners this ability to request. And you also aren't going to be able to have you also aren't going to be able to have rules that, say even if you ask for a privacy fence, you still can't have it. Like, you can't effectively prohibit them by putting so much in the rules that you're essentially prohibiting them. So you are going to have some reasonable criteria for the privacy fences, but you're not going to be able to prohibit them. If you want to prohibit them, then it's going to be a declaration amendment. All right. Similar. So the declaration is the same declaration, right? So you got to get DRC approval before installing improvements, which are defined as all these things. Association wants to prohibit basketball hoops from being attached to the residence. What do you guys think? Is that something they can do through a rule? So the answer is yes, they can do that through a rule. What's the difference between this problem and the one we just did? Well, the big difference is the association isn't trying to prohibit hoops altogether. They just want to prohibit them from being attached to the residence. And again, what the declaration states is homeowners can install improvements if they get permission. One of the improvements that they can ask for permission for is basketball hoops. So we can't ban basketball hoops, but we can certainly add criteria through architectural guidelines or whatever we want to call them, where we say, you can only have freestanding basketball hoops, or basketball hoops cannot be attached to the residence, but they can be attached to your detached garage. So those are things that can be done through the rules. if we're not trying to prohibit the basketball hoops. So the key here is we're not prohibiting the improvement, we're just trying to regulate where it's going to go. Hopefully that makes some sense. All right. Declaration says nothing. Okay. Association wants to prohibit smoking in common elements. Okay, so what does that mean? Well, can we do that? The answer is yes, we can do it through a rule. Why can we do it through a rule? We can do it through a rule because we're talking about common elements. And remember earlier I was saying that the association can regulate the use of common elements. We can regulate the conduct and the use of common elements. Okay, so we want to prohibit smoking in common elements, in which case the board has the right to adopt a rule governing that conduct in common elements. Question for you. Can the board prohibit smoking on balconies if the balconies are deemed limited common elements? So in a condominium community where you have a building and the units and they all have balconies and the balconies are limited common elements for the individual units they're attached to. Can the association then prohibit smoking on the balconies through a rule as opposed to a declaration amendment? So the answer is yes, they actually can. It's still a common element. It might be limited in use to one unit, but it's still a common element. Homeowners do not own the limited common elements in a condominium, and therefore the association's right to regulate the use of such limited common elements is still a right that it has. Of course, with the caveat that your declaration doesn't specifically allow smoking on the balconies or on limited common elements, right? So this is all with a caveat that you don't have, some sort of exception in the declaration. But in this case, we have nothing, right? Declaration has nothing about smoking. And so we can prohibit smoking on general common elements as well as the limited common elements. Now, I don't know if you're going to want to do that because, people will probably not be very happy with you, but you could if you wanted to. All right. We're back. We're still smoking here, right? So declaration says nothing. But the association wants to prohibit smoking inside the condominium units. Is that an adoption of a policy or is that an amendment? So we talked about this earlier, right? When we talk about stuff you do inside your unit, that's really, especially like smoking, that's really going to be considered a use restriction. And you're not going to be able to prohibit homeowners from smoking inside their units, just like you're not going to be able to prohibit homeowners from using marijuana inside their units or, things like that by a rule. That's something that can only be in your declaration. And so I know the question a lot of times is, but Alina, the smoke kind of travels. It travels between units, and we've got a neighbor complaining that their neighbor is smoking cigarettes all the time, and the smoke's coming into their unit, and they've got a lung condition, and blah, 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 blah. I mean, it always escalates, right? So what do you do in those types of cases? Well, in those types of cases, certainly you can say it's a nuisance and treat it as a nuisance. But remember, we're in the age of HB 1137 where we can't really enforce continuous violations like that. As soon as the person stops smoking and the odor stops coming in, the violation's been cured. So we're never going to get really past that first letter that says, hey, can you please stop smoking and be more courteous to your neighbors? Or can you install whatever you need to install so that the smoke doesn't travel from your unit to the next unit? But as soon as it stops, they're done. Unless the smoke never stops coming in through the vents, it's a one and done. Every time they smoke a cigarette, it's a new violation. And we're not going to get to the point of issuing fines. We're not going to get to the point of turning it over to legal. So again, unfortunately, with things like that, even if you did have a covenant that said no smoking inside the unit, enforcing that covenant would be extremely, extremely, extremely difficult. And I don't think, given our parameters right now, with the way enforcement has to be done, with the 230-day demand letters before you can, turn it over to legal, I just don't see how it's ever going to get to legal, to be honest with you. All right. All right, amendments must be approved by owners representing a majority of all votes in the association. Okay, sound good? Association wants to get 67% approval just to make sure most owners want the change. So, okay, great. We want to amend the declaration, but we don't think a majority of all our owners is really enough to get the feel or to really know that this is, good for the community. We really think it needs to be 67%. So we're going to put this document out to vote, this amendment out to vote, but we're not going to sign or record it unless we get to the 67% approval. Can they do it? No, they can't. You knew this was coming, right? They have to amend to change the approval requirement. But essentially, if you're proposing an amendment to your declaration and your declaration says you need a majority of all owners or all votes to approve this, and everything's out to vote, you get ballots back from representing already a majority of all your owners, and then you wait for the voting period to end and you're at like 55%, not at 67. The board cannot say, okay, we're not going to sign this and we're not going to record this amendment because it did not get 67%. That is a direct violation of your declaration. So if you want to change what the homeowner approval requirement is, you can do that with an amendment, but you have to get what's required now before this new amendment requirement kicks in. Hopefully that makes sense. So you don't get to be more restrictive, as we said earlier. You don't get to be more restrictive than what your declaration says. All right. So we're going to have time. We're going to have 14 minutes for questions, which is amazing. So don't assume, in conclusion, don't assume. Read your governing documents in detail. All these things that I kind of put up on the screen for you, they're not really readily visible. You actually have to look for them, and they could be scattered in provisions that you never thought would contain that language. So read the governing documents, and please consult with legal counsel. It's so much easier to do it right the first time than to try and dig yourself out once it's done incorrectly. So please do that. All right, I thought this was hilarious. I hope you guys are laughing at this. Posting bills. Can you name all the bills on there? I think I couldn't name like 2 of them. All right. No posting of bills. All right. So we have quite a bit of questions, I see. And I am going to just start from the beginning and head down. Oh, sure, the beginning was at the bottom. So how can I get a copy of the map referenced in the declaration? Maps are recorded documents, so you can get them through a title company. You can ask your attorneys to pull them. You can go online to the clerk and recorder's office and pull them if you know how to look for that. So it's a public record. It's a real estate record, so you can get them fairly easily. Where do the association's design guidelines rank in the hierarchy? So those rank exactly where your rules and regulations rank. They're all the same as far as the hierarchy. They're at the bottom. They cannot conflict with any of the other documents in there. All right. We are a pre-Kiowa community. Is there a single document to show that Kiowa laws don't apply to us? Where would we find this? So just because you're a pre-Kiowa community, that doesn't mean Kiowa does not apply to you. Kiowa still applies to you. There are certain provisions of Kiowa that do not apply to you, but about 60% of it applies to you. If you want to know which provisions apply to you, you actually have to read through Kiowa. And I believe it's section 105 or 107 of Kiowa that kind of goes through and starts listing all the provisions and all the sections that apply to pre-Kiowa communities. I think it's extremely confusing. You may just ask your attorney, but Kiowa does apply to you, just not all of it. Okay. All right, I'm just going through. When a member chooses to lease regarding services, do all services have to be offered to the lessees just as it would for a member? What if your documents specifically define a member? The lessee is not a member, so could a service be at a cost offered to non-members? Well, technically, yes, but I advise, most attorneys will advise against that. We don't want to treat renters differently than owners, and here's why. Although renters themselves are not a protected class, oftentimes, if you look at the demographics of what class renters fall into, a lot of times they do fall into a protected class. And if someone could show that renters fall into a protected class and we're treating them differently than other residents, that is a form of discrimination. Okay? And so based on whatever that protected class is. So let's say it's a minority group. Well, with respect to race, okay, now you are actually discriminating based on race. It doesn't matter if you intend to do it. It's the impact. That's all that matters. So if what you're doing, if you have rules that negatively impact a protected class, you are discriminating. So we generally do not recommend that you adopt different rules for your renters than you do for your other residents. My association uses the term motions. Is this the same as a resolution? I mean, ultimately, I don't care what you call it. If it's something that the board adopted on its own, call it a motion, call it a rule, it's in that same category. So it can't conflict with any of the other documents. And it has to follow all the same may and may nots as we talked about in the class. So ultimately, it really doesn't matter what you want to call them. I have an association that wants to add more board members than what's in the decks. Can this just be voted on in an email vote, or do we need to adopt a resolution to change the number of members? Hey, that's a great question. So if your declaration truly has the number of directors, you can't change that number without amending the declaration, because you would be adopting something that conflicts with your declaration. If you meant it's in your bylaws, which is normally when we would see the number, sometimes you can amend the bylaws as a board without homeowner approval, and so that may be the way to go. Sometimes you can't amend the bylaws without homeowner approval. Sometimes your bylaws will say the number of directors is 3, but it may be amended by board resolution, in which case you could do it by resolution. So there's a lot of circumstances, and in this particular case, you would need to have the association's legal counsel take a look at that to tell you, what you need to do to change the number of directors. But if it's in the declaration, I'm telling you for a fact that you are going to have to amend the declaration and go through that giant homeowner approval process. So if your decks say that no pets are allowed, but we know the law supersedes that rule, is the association at risk if they don't go back and amend the decks to reflect state laws? My thinking is that what if an owner checks docs before the manager takes some sort of action? Well, the laws are not in, your deck is not necessarily in violation of the law. Your deck says no pets, and you can absolutely enforce that unless someone is entitled legally to an exception. And they are entitled legally to an exception if they have a disability and the animal is what they need to have equal enjoyment of the premises. So you don't need to amend your declaration to remove that. You're not in violation of anything. And assistance animals are not pets. They're not considered pets. So I don't think you need to do anything. You're not in violation. You can certainly continue to enforce the no pets restriction unless and until you get somebody requesting a reasonable accommodation for their assistance animal. Our HOA decks say no RV parking in driveways. Our board president said altitude law said the board could make a revision so that RVs would be allowed for 7 days for loading and unloading. That membership approval would not be needed. So they did that without amending the declaration. Sounds like he misinterpreted what altitude law said, created an exception. Thoughts? I honestly can't comment. I don't know who said what. There could be other provisions in this particular declaration allowing the board to do this. So if we told him that, hey, you can do this without amending and you can do it through a resolution, I can only suspect that there is some other language in there, in their documents that allows them to do it. Otherwise, I don't know why we would tell them that. Okay. If owners have a maintenance responsibility for a limited common element balcony, can the association coordinate the maintenance, hiring contractor, scheduling, choosing paint color, etc., and charge back to the owner? It depends. It really is going to depend on what the declaration specifically says. So if the association has, when you say owners have a maintenance responsibility, then I assume you mean they have the repair, the painting, all replacement obligation for the balcony. And if that's the case, the association really shouldn't be coordinating anything. It should be the homeowner who's doing that, but going through the architectural process to ensure what they're doing complies. Not much different than like a single family home. You know, we're not going to go do the work for them, but they do still have to get approval to be able to do whatever it is they're doing. Do amendments require the vote of members? Resolutions do not require a vote of the members. Right, resolutions are adopted by the board. No homeowner approval. Your covenants, your declaration, if you're amending your declaration, you're going to need anywhere between a majority of all your owners to 67% of all your owners. That's state law. Your articles of incorporation, it really just depends what they say, but usually it's a majority of quorum. And your bylaws are also typically a majority of quorum, but there's a lot of things that boards can change on their own in the bylaws without having to go through homeowner approval. To solve the HB 1137 problem about curing violations, and so if somebody stops smoking for a day to cure the violation, can we make a rule that says to cure an odor or noise violation, the unit needs to go 30 days without a complaint? You can make that rule, but it probably will not be enforceable because that's not how the law is going to look at it. So, I mean, you can make that rule, but you're still not going to be able to get past, you know, you're not going to get to the fine process. You're not going to get to the attorney process. So unfortunately, we can't get around the law and what it requires. When do you go back to Kiowa if declaration, bylaws, and articles do not specify what can be done? Oh, that's a great question, and it's very broad. It just depends on, I mean, you have to check with your attorney because the attorneys know what's in Kiowa and what it addresses and what it doesn't address. So I would say consult with your attorney unless you want to read through Kiowa. There's just, you know, we kind of know what's in there. Do all amendments and resolutions need to be recorded with a clerk of the court? Only amendments to your declaration get recorded, and they get recorded with the clerk and recorder's office of the county. It's not with the court. It's with the real estate records. Okay, so that's where, and your bylaws don't get recorded, and articles get filed with the Secretary of State. All right. All right. I think I'm at the end, and this is perfect timing. Thank you, everyone, for joining. I really appreciate it. We will see you next month, and hopefully have a great evening. Bye, everyone.